It's now my great privilege to introduce this year's Luncheon speaker, the Honorable Douglas Ginsburg. Judge Ginsburg is a Cornellian. He received his bachelor's degree from Cornell in 1970. He's also a Cornell grandfather, and then he was saying before, 11 members of his family have attended college or some other level of their education in Ithaca, and so he comes from a great Cornell family. Earned his JD from the University of Chicago, for which we'll forgive him. After law school, he worked for Justice Thurgood Marshall on the U.S. Supreme Court as a clerk, and then after clerking, he went on to a career that included time as a member of the faculty at Harvard Law School, as the administrator of the Office of Information and Regulatory Affairs, as the head of the Antitrust Division of the Department of Justice. He was appointed to the U.S. Court of Appeals for the District of Columbia by President Reagan in 1986 and served as chief judge of that court from 2001 until 2008. Because being a federal judge is not time-consuming enough, Judge Ginsburg has consistently spent time while on the bench in law teaching, and he's taught at the University of Chicago and at NYU, and he's currently a professor of law at the Antonin Scalia School of Law at George Mason University. He's also a visiting professor at University College London Faculty of Law. Judge Ginsburg will be hosting this year a new PBS series, which will air nationwide on public television, entitled A More or Less Perfect Union. And the series explores the foundational document that governs those who govern us, the American Constitution. And that series serves as the inspiration for his discussion with us here this afternoon. Please join me in welcoming the Honorable Douglas Ginsburg.
Thank you, Dean. It's always good to be back at Cornell, sort of are now. Just to make the experience complete, we checked into the Cornell Club this morning. It's where we always stay. So as the Dean said, this is a 3-hour television series, and it's going to be showing here on WNET March 8, 15, and 22. And it's already, I think, screening on one of the other stations that's carried by cable here. The genesis of this, some 3.5 years ago, was really stimulated by the desuetude in civics education in the United States. So many school systems have eliminated civics, or some of them history as well, and we have a rather frightening level of ignorance, particularly among younger people, about the Constitution. So we set out to join what I think is becoming a spreading backlash against that problem. Many organizations now trying to encourage civics education. And what I'm dealing with here with these 3 hours will appear in about 15 segments with critical thinking questions that will be distributed to the 200,000 teachers who have signed up for this through the Free to Choose network. And the program is available now streaming from pbs.org and from freetocoosenetwork.org. So we were given a constitution that was, as one of the scholars in the program says, probably the most perfect secular document ever written. And it depended mightily upon the structure of the Constitution to protect our liberties. The not afterthought, but reluctant addition of the Bill of Rights that has now, in the 20th century and beyond now, come to play the role that originally was attributed to structure in protecting our rights. So what's happened is that the structure has been eroded. The framers expected politicians, office holders, to guard their powers jealously and to keep each other in check. And in fact, that's not what's happened. And it hasn't happened because when the branches, the political branches, have deviated from the structure of the Constitution as spelled out clearly in the text, they have been indulged by the Supreme Court. And indeed, the Supreme Court itself has engaged in this kind of power grab on more than several occasions. And by power grab with the Supreme Court, I mean taking into the Constitution things that the framers left to ordinary politics, left to democratic politics, and instead has been absorbed by fiat into the Supreme Court's version of the Constitution. So I have a clicker here. I'm going to get us a little bit of, just to set the stage and remind you of what the Chief Justice said, Chief Justice Marshall in 1803. You can read it there. The idea is to hold up the Constitution, look at the enumerated powers of the branches, hold up the statute that's been passed or the executive action that's been taken, and see whether it fits. And if it doesn't fit, by implication, it is invalid. And the court will tell us which of when that happens. And that was the reigning approach to constitutional adjudication for well over a century. Here is an example from 1905. The Constitution is a written instrument, the point that Marshall was making. As such, its meaning does not alter. Now, that may seem a peculiar sentiment because the Supreme Court has been altering the Constitution in fairly easily seen ways for quite some years. So at this point, I joined a debate that has been really circulating in legal academia and the courts since 1985, coming from a debate between, not a simultaneous debate, but conflicting speeches, from Attorney General Meese at the ABA in 1985, entitled A Jurisprudence of Original Intent, and for which Justice Brennan replied with an essay called A Living Constitution. And that set the stage. Now, jurisdiction of original intent has evolved through scholarship to original public meaning, that the words should be understood as they were understood by the people who wrote them and who ratified them.
The written Constitution is all that matters. We, the people, is how it starts.
I'm afraid too many people worship the Constitution. We are being ruled by people who have been dead for 200 years.
How should the living interpret the words of the dead? The debate comes down to the document's original meaning versus a living Constitution.
Originalism is simply the proposition that the meaning of the text of the Constitution must remain the same until it's properly changed.
It's actually very hard to discover often what the original meaning was, because the text of the Constitution often doesn't give you that much guidance.
And I think we delude ourselves if we believe that there is some objective meaning or correct answer.
I don't believe that. If that's true, I can't see the point of having a written Constitution in the first place.
I'm one of the living guys. I believe that the Constitution is ever evolving.
There are going to be circumstances where we have to interpret the meaning of a word. I happen to be fairly limited in how far I'm willing to go.
But originalism does not say, and stick with that through eternity. Article 5 of the Constitution specifically contemplated that the Constitution could and should be amended.
The problem is the Article 5 amendment process is extremely difficult. It's very, very hard. I think the best way to think about a written Constitution is it's a starting point, but it's not the ending point.
Of course, we do our best to understand what the text meant at the time, but for all of the debatable issues, that's a starting point.
If you're a living constitutionalist, it could be whatever you want it to mean. In fact, the only living constitution is a constitution that's followed.
That has almost nothing to do with modern judicial review, because in all modern cases of any importance, the Constitution is not clear.
We're not writing on a blank slate, but we are filling in the blanks and figuring out what the Constitution should be.
The Constitution does evolve, but it evolves slowly. It evolves with the time. It needs to be tweaked.
All of us agree that the Constitution should be updated. What we disagree on is who is to do the updating.
That's what the political process is for, to resolve those difficult questions.
The last people you want to be changing that document are judges.
The judiciary is not licensed by the Constitution to add to or subtract from the text of the Constitution.
What the Supreme Court says it means is not actually the Constitution. The Constitution is the Constitution.
The idea that the Constitution should evolve is really inconsistent with it being the law of the land, the supreme law of the land. The alternative is a law that's forever uncertain, no more stable, no more reliable than popular opinion of the time. Opinions change, mores change, the words don't.
So when I'm going to skip through to the thing, we'll deal with that in a moment. When the Supreme Court has departed from the text of the Constitution, the results more often than not have been, well, somewhere between calamitous and disastrous. The first important instance being the Dred Scott decision in 1857, which helped bring on the Civil War, in which the court just made up a constitutional right to own slaves and a prohibition on African Americans ever becoming citizens. And then, of course, in 1893, I think it was, maybe 96, in Plessy against Ferguson, they invented the separate but equal clause. Find that in the Constitution. Where's the separate but equal clause? This goes on, and it gets much worse in a way in the 20th century because it becomes a habit. And there are, I'm going to stay with a couple of examples that are probably familiar to you because some of them would others would take too much time to go into. So here's a nice, simple one. The Congress shall have the power to regulate commerce among the states. There isn't a peculiar word in there anywhere. Randy Barnett did a study of the Pennsylvania Gazette, which has been digitized, and found 1,500 references to the word commerce in the 50 years or so preceding the drafting of the Constitution. And all but 2% clearly meant trade. And of the 2%, 1% was ambiguous and 1% were sort of outliers that didn't seem to fit. Let's take a look.
Ernest Hemingway slept here. Now they do, descendants of Hemingway's six-toed cats. The Hemingway home is dedicated to preserving the legacy of author Ernest Hemingway and of his cats. In Key West, anything goes. Chickens need no reason to cross the road, or a license for that matter. But when the Federal Department of Agriculture got wind of the museum's cats, it dictated how they should be cared for.
The museum challenged it on Commerce Clause grounds and said these cats are marooned at the very southern tip of Florida, will never cross the state line, and furthermore, they were not bought or sold, they were merely born.
To the framers, commerce meant I send something to you in Boston when I'm in New York. That was interstate commerce of the kind that could be regulated. When two people in the same state traded something, that was not interstate commerce and therefore could not be federally regulated. That was the intention of the framers.
The framers didn't design an almighty federal government that could reach down right into your backyard or barnyard.
During World War II, there was a farmer who grew grain, and he fed that grain to his own animals.
And the federal government had a program at the time that dictated how much wheat farmers could grow on their own land. And he said, hey, that's not constitutional. Why? Because I'm not engaged in interstate commerce.
But in Wickard versus Filburn, the highest court in the land thought otherwise.
And in a convoluted analysis, the Supreme Court declared that because that wheat would not be used in interstate commerce, it still impacted interstate commerce through some type of displacement.
So they're taking the Commerce Clause and stretching it like a rubber band to apply to any kind of business when it was originally meant just to be for cross-border commerce, like it says.
I agree, but some scholars disagree. In their view, there's little, if anything, beyond the regulatory authority of the federal government.
In an economy like ours, things really are interconnected. And what goes on one farmer's farm really does affect what happens elsewhere. And so when the Supreme Court says the Interstate Commerce Clause gives Congress the power to regulate things that seem awfully local, it's not just engaging in some kind of trap to expand federal power. It's recognizing an economic reality.
If the test under the Commerce Clause becomes does it affect commerce, then everything affects commerce, whether you do something or don't do something.
Well, once you have the power over anything that affects commerce amongst the states, then you basically have the power over everything.
Everything? Even Hemingway's cats?
The 11th Circuit Court of Appeals, and I kid you not, said that because the museum features these cats on its website and has cat-related merchandise in its gift shop, that is a substantial connection to interstate commerce, and that opens the door for the federal government to come in and exert control. Not making that up.
So precedents had been pretty clear prior to Wickard against Filburn that labor relations, mining, retailing, manufacturing are not interstate commerce. The trade in the goods that are manufactured is, of course, but those other things are local and not within the reach of the federal government. So the Supreme Court decided otherwise in Wickard and basically annotated the Constitution to read this way. No matter how local, it may not be regarded as commerce, it has a substantial effect on interstate commerce, direct or indirect, that's enough. Now, in practice, over the years, substantial economic effect on interstate commerce, I suggest, it could more accurately be described as a discernible effect on interstate commerce. It doesn't take anything substantial at all. So this has completely changed the relationship, not this one decision, but the many, many ones that depend upon it, completely changed the relationship between the federal government and the state governments in a way that was also done in the 17th Amendment, when the senators were no longer chosen by the state legislatures, but rather by direct election. And that was done the proper way. It was done by amendment. Now, the result has been that the states aren't represented in Washington, and so obviously power is going to flow to the central government and away from the states, which is what happened. But it was done legally in the way that the framers prescribed. Not too much to ask, it seems to me. Nor shall private property be taken for public use without just compensation, a provision in the Fifth Amendment and then repeated. And this was taken quite seriously and literally for a long time. In the late 19th century, the Supreme Court said, you know, this isn't sufficient protection for private property because a hotel is used by the public, a theater is used by the public, so that's kind of public use, so it must be that it has a public purpose. In other words, it has to be both a public use and a public purpose. And the court in the Kelo case recounts this in an ironic way, basically saying, well, we switched to public purpose a long time ago. Forget public use. It's not two requirements. It's just a public purpose, which is very broad. And so if you see the second quotation, if the taking serves a public purpose, then that's good enough for us. That's a public use, even though public purpose is much broader. Now, in that case, if you don't recall the facts, the City of New London decided to clear an area to build for a campus that Pfizer wanted to build there, the drug company, and never got built, by the way. And Suzette Kelo didn't want her to sell her house. This was not a blighted property. Some of the area that was condemned was blighted, but not this little area where she was, or part of the development area. The idea was to clear it out, turn it over to Pfizer for the purposes of increasing tax receipts based on property value. And so the court just rewrites it, nor shall private property be taken for a public purpose, such as economic development.
As a kid growing up with pianos, I remember the first time I ever broke a string, my dad said, "You broke it, Charlie, you're gonna fix it." The first musical director of one of the casinos, he came to me and said, "Charlie, I have a lot of pianos here." So that's what started my career in piano tuning in Atlantic City.
At the beginning of the 20th century, Atlantic City was America's playground. But after World War II, its fortunes declined. The city then gambled on casinos and lost big. Much of America's playground is now a casino wasteland.
This building is not just walls. This building is a cross-section of my life. It's like a living, breathing thing. We were blessed to be able to come as immigrants to this country after what my parents had survived the Holocaust. And the idea of actually owning something that we couldn't be thrown out of was huge.
But maybe Charlie could be thrown out. In 2014, a state judge ruled the Casino Reinvestment Development Authority could seize Charlie's home, using the state's power of eminent domain.
And you have 45 days to vacate, and that it would be bulldozed as all the other buildings right next to me had been bulldozed.
Does the public use provision of the Fifth Amendment have any meaning whatsoever? And the Supreme Court's answer by a 5-4 vote was effectively no.
The Constitution provides that private property may be taken for a public use with just compensation paid. But the Supreme Court rewrote public use to read public purpose, which is much broader.
And the thing that was crazy in the Birnbaum cases, they weren't even sure exactly what they were going to use it for or when they were going to use it.
They said, we don't have to give you an answer. I'm thinking, where do we live? Is this Russia? Is this North Korea?
It's just a naked abuse of government power.
So Charlie went to court. 2 years later, the judge deemed the state's effort to oust Charlie a manifest abuse of the eminent domain power. New Jersey appealed, but in the end, Charlie prevailed. In the infamous case of Kelo versus New London, Suzette Kelo wasn't so lucky. The Supreme Court said, we can't decide what a public purpose is. We'll let the city councils decide that. That's good enough for us. Funny, but I had thought the justices were supposed to make constitutional decisions.
So the battle goes on.
So the reaction to this case, this high-handed rewriting of the Constitution, was that 46 states changed their laws, mostly by statute, some by judicial decision. New Jersey was not one. The decision in Charlie's appeal set the standard in New Jersey, which was it was not permissible to acquire land, to hold it without an immediate plan for a legitimate purpose. Florida has the toughest one of all. I won't go into the details. It was something that could never, ever have passed had it been put to the people. But it was just, we were just overridden as the constitutional document was literally overridden. So there's what it said twice, once for the federal government, once for the states, and that's how it was amended. Oh, wait a minute, where is it? I hope I've got it in here, go back. Well, I don't have it, okay. So it would have just said, can be taken for, may be taken for a public purpose and including economic development. That was as broad, that's how broad it was. This is a little complicated, and I want to leave 15 minutes for questions and answers. You've got the flavor of it. The program has to be entertaining, and I hope you see that it is, and the production values are very high. We're going to bring to the public television audience an awareness, at least, that there is a legitimate debate about this. Most people were born into the world in which the Supreme Court revises the Constitution and have accepted that because they're not lawyers and they're not particularly active in these sorts of things. But it doesn't have to be that way. And at least we want a more literate public and a more well-informed body of secondary, 7th, 8th, and secondary school students being graduated. You see that both sides are represented in all of these issues. They have to be. We wouldn't be on public television otherwise. So I hope you'll take a look at all 3 hours. We previewed It debuted the first hour last night at the National Archives in Washington. As I say, all three are available from pbs.org or freetochoosenetwork.org, as are the DVDs if you wanted to send it to somebody or just send them the link. So, questions? Christine, how do we do this? Are there microphones? Ah, there we go.
Judge Ginsburg, I'd be interested to know, after your discussion of Dred Scott and Plessy, whether you think Ollie's Barbecue was also wrongly decided.
Was also?
Wrongly decided, a Commerce Clause case.
Right, right. So this is a case in which the Supreme Court said that the Civil Rights Act of 1964, I think it was, or was it the Equal Protection Clause directly, it was the Equal Protection Clause authorized the Civil Rights Act of 1964 affecting places of public accommodation, that is to say, private places. And of course, the 14th Amendment, fifth provision of the 14th Amendment authorizes the Congress to pass implementing legislation. It's still a close case, I grant you. It is a close case. I don't think it is a case in which you can say the Supreme Court didn't have a textual hook from which to work. That's not true of some of these other cases that I've mentioned. Got 100 lawyers here with an opportunity to question a judge. Turn the tables a little bit. Yeah.
Over here. Justice Ginsburg, thank you very much for joining us this afternoon. And I truly commend you for putting together a program to engage high school students in civics. I certainly agree that education is needed in perhaps this area. So here's my question. Metrics around how you will assess whether the program has been successful so that perhaps it's repeated and or further deployed and amended.
Well, it's a good question. And if it is successful by the metrics that we will use, we're thinking we will follow up with a single hour on the Declaration of Independence. But the answer is that the production company does solicit and get feedback from teachers as to whether they use the program and how many students they have. Typically, this, based on things they've done in the past, we're expecting this to reach 1.2 million students a year, and it will be evergreen for as long as these issues remain pertinent. And the public television audience, I think their PBS has the metrics that we need. We've been very fortunate to have WNET as our sponsor within public television, and they're doing the promotion inside the network and are enlisting about 200 stations to exhibit the series. So it's a great question, though, because we're totally dependent on being able to show that it has been successful with teachers. Sir?
So I guess my question is, if you put into this sort of concept that we're distorting the Constitution, there's also the principle of stare decisis. What then do you view as the solution that judges should be doing to go back to a more original Constitution, and how does that conflict with stare decisis?
That's a really good question, and only a lawyer would ask that question, right? And maybe only a lawyer could answer it. All right, so when he was at his confirmation hearing, Bob Bork was asked essentially that question. And the answer that he gave, and I think it's a sensible one, was there have been huge reliance interests built up around many of these programs that wouldn't have been permissible, these programs that wouldn't have been permissible under the original Constitution. And it would be folly to simply broadly destroy those reliance interests. But we certainly needn't compound the problem going forward. Now, relatedly, one of the separation of powers issues most important in the way that the court has tolerated a distortion of the Constitution is to allow agencies to act as lawmaker, prosecutor, and judge. The Securities and Exchange Commission, the Federal Trade Commission, these agencies, many of them, scores of them, have an internal tribunal with an administrative law judge. The agency authorizes the staff to bring the case. Their people who work for them prosecute the case, and they ultimately are the judges in the case. Madison said the combination of functions is the very definition of tyranny. And that was a novelty. It was done once in 1887 in the Interstate Commerce Act, and repeated several times in the early 20th century, and then infinite number of times during the New Deal. But the Supreme Court, when this was challenged in the mid-1920s, upheld it, even though it was right in the teeth of the separation of powers. And everybody knew that. That could be corrected easily, and there are cases percolating up now that will challenge that. Now, there have been a couple that were diverted into a decision that the administrative law judges had to be appointed by the agency head. They couldn't be appointed by a lesser official, but that depended on the definition of an officer of the United States in the Constitution. But there will be challenges now over the next few years to these internal proceedings in which all functions are combined in one hand. And that would not be terribly disruptive. The Federal Trade Commission and the Department of Justice Antitrust Division both administer the Sherman Act and the Sherman Act. The Justice, of course, has only they have criminal enforcement, but both have civil enforcement. The FTC has an internal tribunal. For 20 years, no one who was charged was ever exonerated by the commission, although about 20% of the cases found the administrative law judge saying one or more of the counts was invalid. That was uniformly reversed for 20 years by the commission itself. The Department of Justice, on the same statute with the same allegations, goes into federal district court. Now, they win most of their cases, but not every case for 20 years. And when I asked Chairman Ramirez of the FTC how she accounted for this, she said, we're very good at case selection. You know, well, I'm sure they are, but so is the Department of Justice. Right? So I don't think that's a good explanatory variable. So anyway, that's just an outrage, and it's a complete distortion of the Constitution. Sir, Mr. Rosenblum, as I recall.
Might it be possible to infer from the jurisprudence for which you're arguing that constitutional rights such as privacy, which are not specifically enumerated in the Constitution, would, under the right circumstances, go by the boards?
Well, the Constitution makes no specific provision for privacy. In the Griswold case, the Supreme Court found that there was a sort of implication drawing from 5 different provisions, 4, I think, in the Bill of Rights and 1 in the original Constitution. But what did they mean by privacy? They didn't mean informational privacy. They meant marital privacy, privacy with, and in fact, it wasn't even privacy in that sense. It was the ability to purchase birth control materials, which was unlawful in the state of Connecticut at the time, which was in the 1950s. So I think the answer there is that the Ninth Amendment is their best hope. The Ninth Amendment says that the enumeration of the rights in the Bill of Rights is not to be taken to deny or disparage rights that have not been enumerated. And indeed, the opposition to having a Bill of Rights was that that would be the inevitable implication, that if it wasn't listed, it didn't count. And Madison and Jefferson were both of that view. Madison got gerrymandered, and by the way, Mason wouldn't sign the Constitution for lack of a Bill of Rights, which Virginia had. He had written it. 4 states, starting with Massachusetts, said, we won't ratify without a Bill of Rights, and they ended up saying, we ratify subject to the understanding that the first Congress will append a Bill of Rights and send it to the people for ratification, and that's what happened. So Madison had to change his tune. He got gerrymandered into an anti-federalist district that their idea of a Bill of Rights was no standing army, return the navigable rivers to the states, all that sort of thing. He wrote these amendments. He had a hard time getting floor time in the House, and he took it over to the Senate, and the same thing. When it was finally ratified, when they were sent out to the states and ratified, the church bells did not ring. It was yesterday's issue. and it pretty much lay dormant for 100 years. But as the structural protections began to erode, attention turned to the Bill of Rights as a way of protecting us. The Ninth Amendment says these other rights are not, just because they're not enumerated, are not gone. So where are they to be found? They could be the rights of Englishmen in 1791. We did fight a revolution to get the rights of Englishmen. It could be the natural law that is invoked in the Declaration of Independence. That's the most likely source. But the Supreme Court has never resolved a case based on the unenumerated rights in the Ninth Amendment. In the Griswold case, it listed that as one of 5 provisions that it said suggested that there was a right of privacy. So they've just snipped it out of the Constitution. That would be the place where you would have some opportunity to say there's an inherent natural right to a certain degree of privacy from intrusion by the state. Up here, sir? No, we're back there, sorry.
Thank you, Judge, and I appreciate your comments. I think it's a wonderful thing that you're educating the younger generation and educating people who watch public television. But my concern is educating people who are not in those categories. And they're going to be part of the voting bloc this coming year and in the future. How do you educate those people? And I'm not trying to be nasty about what education they've had going up, but how do you reach those people to give them a basic sense of constitutional construction and the government?
Well, I think if over a period of even as little as a decade, students are graduated with some understanding of our constitutional heritage, then as they become journalists and lawyers and other people with an influence on public opinion, they will reflect that. It will take time. That decade made just the way an opportunity to begin. But it took a lot of time to do this to the Constitution. It's going to take a lot of time to restore some sense of textual integrity. When Churchill was not reelected in 1946, a young man came up to him and said, "Mr. Churchill, this will be the ruin of the nation." He said, "Young man, there's a lot of ruin in a nation." And it's true, we have survived. We have done well. Imagine what we could do. Imagine if our liberties were totally restored. And they're always under assault. Look what's going on campuses, including in the show. We've got Berkeley and the University of Missouri, 2 public institutions in which speakers are not being allowed to present their views because of a mob, and the university and the local authorities are not protecting those speakers' opportunity and their right to speak there. The thing you saw at the very beginning about the First Amendment, there was a journalist being blocked on the Berkeley campus by a bunch of hooligans trying to stop a speaker because his words would be offensive to them.
I suppose the First Amendment is a good introduction to my question, since I am the director of the First Amendment Clinic at Cornell Law School. I'm not sure I precisely agree with the characterization you just made. Some of the hooligans are, protesters who have the right, obviously, to do it, provided they're not they're trying to deny the person the opportunity to speak themselves.
Well, that's what made them hooligans.
Well, one person's hooligan is another person's, protester.
Which amendment?
But let me get back to the words, because words like hooligan and protesters makes me think that you certainly did provide examples where there's clear words in the Constitution, and we could sort of see what they mean. But there are other words in the Constitution that we can't do that. And the words that come to mind right now are high crimes and misdemeanors. I know for one thing that misdemeanor in that phrase does not mean misdemeanor. It means something different. So what do we do in circumstances where we have a vague phrase like high crimes and a phrase that the word actually doesn't mean precisely what it says in misdemeanor?
There's a wonderful 2-volume book called The Founders' Constitution by Philip Kurland and someone else, which is just a compendium for every clause in the Constitution, providing background documents where those phrases were used. And so many of them were, like the one you just mentioned, are legal terms, and they show up in English statutes, in English decisions, and so on. And so there's no question that you would want to see first, what did it mean, right? Who would put on that's 230 some years, right? Take 400 years. Who would put on a play by Shakespeare and not try to understand what the words meant? It would be ridiculous if you didn't do that. So what we're seeing now, with the exact phrase that you've mentioned, I haven't watched closely these proceedings, but my understanding is that there's argument about that point. And as long as politicians are arguing about the meaning of the Constitution, the Republic is safe. It's when we depart from that. They're all trying to figure this out, sure, with a partisan agenda, but so what? They are trying to make a decision based on a legitimate understanding of what those terms meant. It's a perfect example. It's not something that anyone claims has evolved. Okay. I don't think so, anyway. No, they're all trying to say, what does it mean when it was written?
To possess the right to own arms, or if you interpret the comment differently, that they do.
In the show, we point out that about the Second Amendment, that the preliminary clause, introductory clause, does not govern the substantive clause, just as the Supreme Court has said with regard to not only that provision, but the copyright provision, copyright and patents, which says in order to further the works of artists and scientists or something to that effect. And they say, well, that doesn't limit what comes after. Same thing here. That's just a matter of English grammar. But what the court said in the Heller case was that the right was the right of citizens, militia were all the male citizens above 16, or 16 or above, does not diminish the right that they had at the time, which was to have weapons for self-defense and for hunting. So there are probably 30 or 40 decisions now in the courts of appeals since Heller dealing with various provisions that counties and states and cities have implemented or passed, trying to limit what one can exactly one can do. I had the one when the District of Columbia rewrote their statute after the Heller decision. I had the subsequent challenge to that. It came up twice, actually. And we upheld registration requirements, and we upheld about 5 or 6 things and overturned several others that were really just a burden on gun ownership without serving any meaningful safety purpose. So California, one of the counties said you can't bring firearms onto the county fairgrounds or into a public building. That was upheld in the Ninth Circuit. What most people want to think about is, well, what about, surface-to-air missiles and cannons and so on? Well, that was not something that it's not even the equivalent of something one would own for hunting or self-protection. It's an important point. I mean, Heller is not a decision that hasn't any limits to it. It was very clearly grounded in practice and the understanding at the time.
So Judge Ginsburg, Justice Gorsuch has written that it's no accident that over the last 40 or 50 years we haven't seen any new constitutional amendments, and that has coincided with sort of the reign of living constitutionalism. And it struck me that now, we're hearing more about the Equal Rights Amendment and how that might be coming up to be passed. Do you think that's because we now have a conservative appointed majority on the court, and perhaps the reign of living constitutionalism is coming to an end? We're turning back to passing new amendments?
Well, I'd need a lot more data points than that to reach such a happy conclusion. But Virginia just ratified the Equal Rights Amendment, making it the 38th state. But there are 2 legal complications, one of which is that when the Congress sent the provision to the states in, I think, 1972, they set a time limit on the period for ratification. Not clear whether that can be done. It was not specified in the Constitution itself. Secondly, the time limit, which I think was until 1980, caused 3 or maybe 4 states to rescind their ratification, saying the time has passed, it didn't pass, and political winds probably changed in those states, and so they de-ratified it, if you will. Not clear whether that can be done. So it's going to have to get sorted out. And clearly the Supreme Court's going to have to resolve that. Case was filed yesterday by 4 states, I think.
Judge, when I started college, I had a slide rule, which I had to use. Most of the young people here have no idea what I'm talking about. My point really is that my assumption is that Hamilton and Madison did not have email addresses. And as a consequence, we are now living in a completely different age. But the point I want to make is that the concept of one vote for each person in the country is a concept. But the question is, how do you amend the Constitution? Because it's difficult, as one of the commentators said, to basically eliminate the Electoral College and make it a one vote per person democracy in the United States.
Well, there's only one way to do it, and that is to get it through the House, get it through the Senate, and get it ratified by 38 states. I should have said it with the president's signature. It's not going to happen because many states would be defeating their own interest, saying, let's let New York and California decide every presidential election. So that's not going to happen. And frankly, I think it's a good thing that it's not going to happen, but that's beside your point.
Yeah, I mean, what I'm really saying, in many respects, the Constitution is really not a living document that...
Well, that's a provision that's so clear, like the age limitation for holding the office of the presidency or the Senate or the House, that the court has not been so bold as to just rewrite those. There was a time, by the way, when it looked like the Electoral College was going to be subject of an amendment in the Congress in the early 1970s. And it was many of the members, there was a majority in at least one of the houses. They hadn't voted. They changed their minds as the debate unfolded.
Judge, another provision that's seemingly clear in the Constitution is that Congress shall have the power to declare war. And that principle has seemingly been tested more and more aggressively by the executive in the last 15, 20 years. I was curious what your take is on how you see this continued clash between the legislative and executive branch shaking out in this area going forward.
We haven't declared a war in a long time. Every war that the Congress has declared has been won. Not so of many of the conflicts entered into without the support of the Congress. Now, of course, they've appropriated the money, but they haven't made a declaration. And it's not clear to me whether the Congress is even unhappy with that, because it avoids their responsibility to vote on these things. Take the parallel provision for ratification of treaties by the Senate. Where a consular office is established is done by executive agreement and has been forever. There's no need for sign a treaty over that. The Iran deal had all the earmarks of a treaty. It was not submitted to the Senate, and there were only about 4 senators who objected and said, submit it to the Senate so we can vote. It would not have passed. Sentiment was running something like 96-0 against it, and so it wasn't submitted. And no one has standing to challenge that. But the Congress is very happy to delegate its powers to the executive and not assert itself when its powers should be triggered. Who's for clean air? Oh, I'm for clean air. I'm for clean air. Who wants to write the regulations that burden various segments of the public? Well, let the EPA do that. Let people complain to the EPA, not to me. And then I'll write a letter on behalf of my constituent, which will do no good. So this delegation of authority has completely eroded the responsibility of the Congress to make hard decisions. About 40 times a year, a regulation with the force of law is evaluated by OMB because it costs more than $100 million for the public. That's not too many times ask the Congress to vote. Do you want this or do you not want it? But no one asks the Congress, and they don't want to be asked. And that's where your rights have gone. Thank you, Dean. Thanks very much.